Hello and welcome to the Mander Handley podcast, where we explore legal issues that affect everyday life. Today we're talking about inheritance disputes and in particular Inheritance Act claims. We're explaining what you need to know if you feel you've not been treated fairly and want to dispute a will or estate. When a loved one dies, it is not uncommon for disagreements to arise over how their estate has been distributed. Many people may assume that if a will already exists, it cannot be challenged. However, the law does recognise that there are situations where a will or the rules of intestacy fail to provide reasonable financial support for certain individuals. One of the most common claims to dispute this is an Inheritance Act claim. In this episode, I'm joined by Amanda Hyam, our Head of Dispute Resolution and Employment at Mander Handley, to explain how Inheritance Act claims work and how they can support you. So Amanda, what is an Inheritance Act claim and when does it arise?
Okay, so an Inheritance Act claim allows certain individuals to apply to the court for reasonable provision from an estate. Claims commonly arise when someone has been completely excluded from a will. They can also arise where a person has received some inheritance, but it does not meet their reasonable needs. So claims may also arise where there is no will and the rules of intestacy produce an unfair or impractical outcome. The claim is not about rewriting the will entirely, but addressing the financial needs of those who are not inheriting under the will or have been partially excluded. It focuses on fairness.
Who's eligible to bring an Inheritance Act claim?
So only certain people can make a claim. A spouse or civil partner can. A former spouse may claim, provided they've never remarried. Cohabiting partners can make a claim. Children and individuals, that includes stepchildren as well, and adult children, all may be eligible. And those who were financially dependent on the deceased prior to the deceased's death.
So what does reasonable financial support mean?
Reasonable financial provision does not necessarily mean receiving an equal share of the estate. For most claimants, it is defined as provision reasonable for their maintenance. This includes housing needs, living expenses, and basic financial security. However, each case will be assessed on its own circumstances.
How does the court decide whether a claim should succeed?
Okay, well, the court considers a variety of factors under Section 3 of the Inheritance Act. The applicant's current and future financial needs, the responsibilities the deceased had towards the applicant, the size of the estate, including liquidity, any physical or mental disabilities affecting the applicant or beneficiaries, for spouses and civil partners, the length of the marriage or partnership and contributions to the family, all of that relevant, but no single factor is decisive, and as said, the court assesses all relevant circumstances.
Are there time limits for making an Inheritance Act claim?
Yes, there are. So generally, a claim must be issued within 6 months of grant of probate or letters of administration in an estate with no will. The clock starts running once the grant is issued, not the date of death. Claims issued outside that 6-month window will require court permission, so you do need to be careful not to miss the date, because the court will look at the reasons why you delayed bringing a claim and potential prejudice to any of the beneficiaries. Permission is discretionary and therefore not guaranteed. Early advice can help you understand your options.
What information is needed to bring or defend a claim?
So, applicants have to provide full financial disclosure, including income, savings, assets, liability, monthly expenses, and evidence must be brought by the applicant, and the executors have a duty to provide full details of the estate to the court, including assets, liabilities, terms of the will, or intestacy. Beneficiaries defending a claim are not obliged to disclose finances. However, if they don't, the court may refuse to allow them to raise a needs-based defence to the claim. Accurate and early disclosure helps claims progress more efficiently.
Do inheritance disputes always end up in court?
No, they don't. Many are resolved without a final hearing. The courts encourage and solicitors should explore negotiation at an early stage. Mediation is often used and can be very successful. Alternative dispute resolution can also reduce costs and delays. Alternative dispute resolution can be particularly valuable when ongoing family relationships exist. Get everyone round a table and try and iron out the dispute. Court proceedings can still be issued and should be to protect time limits. Even whilst settlement discussions continue, you can agree standstill agreements with the other side.
If court proceedings are unavoidable, what power does the court have?
Right, so the court has complete discretion when making orders. It can award lump sum payments from the estate. It can order regular maintenance payments. Property can be transferred or settled for the claimant's benefit. So orders are tailored to the claimant's needs and the size of the estate. The goal is to achieve a fair outcome.
Thank you, Amanda. Inheritance tax claims can feel daunting, especially when there are strict deadlines or if you have family relationships you want to hold on to. Whether you're a potential claimant, a beneficiary, or an executor, early legal advice can help you understand your rights and if an inheritance tax claim is right for you. If you are concerned that a will or estate may not have reasonable provisions, the team at Mander Handley can guide you through your options and help you work towards a fair resolution. Please call us on 02476 631 212.